crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome in to the attorneys. Thank you for joining us tonight. A really interesting guest we have tonight and topic of conversation. So looking forward to tonight's show. So you picked a perfect night to join us. Before we get into the introductions, want to just point out a couple of things for you of how you can be a part of the show, because it's always better when you are involved in the process. So at the bottom of the screen, there are ways you can call, text, email. Feel free to do that all throughout the show tonight. Would love to have to hear from you. Also, Hollis Wright makes available attorneys standing by live for a free off-air and confidential conversation. That's yours for the taking. So anytime during the show tonight, just pick up the phone and call them, text them, get in touch with them, and an opportunity to speak with an actual attorney from Hollis Wright. Speaking of actual attorneys, yes, we have two of them. Leading the conversation is the managing partner of Hollis Wright.
Lawyers are actually standing by.
They're
standing. You do text, you call, you email, you're going to get a lawyer responding to you. Yeah. We're really lucky tonight. We've got Ansley Bennett with the Bloomston firm. Brett Bloomston started the Bloomston firm. He has been a guest on the show many times. Mm-hmm. One of the state's best criminal defense lawyers, a personal friend of mine. And he decided we'd get Ansley today because she is new at his law firm and is going to learn the process of getting on TV for the firm, and we're excited to have you. So I'm super happy to have you over here.
I'm excited to be here.
Well, good. Well, Brett speaks very highly of you, and I know that that's been a good union. But tell us a little bit, how did all that work? You worked with him long before you even were a practicing lawyer.
I did. So I actually grew up in Birmingham, and I knew a lot of the Bloomston family. I didn't know much about Brett, but I always knew I wanted to go to law school. So I went to the University of Alabama for undergrad, and I decided to do my law school at the University of Georgia. And while I was there, I knew I wanted to do criminal defense. I knew I wanted to come back to Birmingham. So I had a dear friend at the U.S. Attorney's Office, and she said, I have the perfect guy for you. Yeah. Introduced us, and I worked for him all the summers that I was in law school, and I couldn't leave, so I'm there full time now. Well,
you struck it rich being with Brett, and he got lucky getting you over there too.
I appreciate that.
What is it about criminal defense work that is intriguing and interesting to you? Because I know it's kind of a calling, and a lot of people get that calling when they're in law school. You at Georgia, how did you know this is what I want to do?
Well, first and foremost, there's never a dull moment. Yeah. It is exciting. It is interesting. There's a lot of just different issues. Each case is so different. And it just makes it really fun to go to work every day, honestly. Mm-hmm. And, you know, protecting people's rights and their liberty is extremely important. You know, I think that we're in a very special position that you're right, it is a calling, but I feel very lucky every day to help people and secure their freedom.
How would you define y'all's practice at the Bloomston firm? Is it comprehensive criminal defense? Does it focus more on felonies and misdemeanors? Kind of how would you define it?
It is every type of crime you can imagine. Okay. We do everything from local municipality dog bite cases, DUIs, all the way up to state court cases. We do federal cases, white collar cases, drug trafficking, anything you can imagine. We handle it at the Bloomston firm.
So I like that.
That's good.
Anything at the Bloomston firm. I like that. That's good. Brett will like that
She's
too.
Learning quick.
Yeah, no, she's learning real quick. So do you agree that it's really important, and Brett and I have talked about this on the show a lot, but super important if you're engaged in some conduct that got you in trouble, getting a lawyer early is important, because you and I both can probably agree, a lot of people will put their head in the sand when something like that happens and just panic about it and just think it's going to go away. It doesn't go away. The criminal courts are there to make sure it doesn't go away. Is getting a lawyer early really important, you think?
It is extremely important. You're right. A lot of people say, well, I'll just wait till I get charged with a crime before I call an attorney. That is the last thing you should do. A lot of people have an idea that they might be charged ahead of time. An investigator might come to their house, leave a card, or if they got in a fight or had an altercation, they might be aware that an alleged victim later went and swore out a warrant. If you have any idea that criminal charges might be forthcoming, you should call an attorney immediately. There's two reasons why. Oftentimes, if an attorney gets in touch with the DA or an investigator, they can actually prevent you from being charged in some cases. And in other cases, if you are going to be arrested, an attorney can work it out to where you can turn yourself in rather than having the police show up at your place of work or your home and arresting you.
You know, a lot of times, in the criminal context, a lot of this is negotiating with district attorneys, U.S. attorneys, et cetera, to try and get the best benefit for your client. Having a lawyer lead, guide, and direct you through that process, holding your hand through that process is super important because there's an ability for you potentially to plead to something lesser than what you were charged in the very first place.
And I can't imagine, I mean, we talk a lot with a lot of different attorneys, a lot of different areas. I can't imagine trying to go this alone. Do people try to figure it out on them like their own?
Some people do. I wouldn't suggest it personally. No. Everyone at some point in time, either themselves or someone they know, is going to have to deal with the criminal court and the criminal process, and it's really complicated. I didn't understand it till I went to law school, and people really don't understand it, and it helps just to have someone there to explain all the different steps and processes that you're going to go through.
Tell us, I want to talk, and I know we're going to go to commercial break in just a bit. I want to talk about the criminal process, like kind of, I want Ansley to walk us through what happens in the next segment. But before we go to break, I do want to talk about, just in general terms, these terms are thrown around and lawyers understand what they mean, but put it in layman terms. Someone's charged with, you know, a municipal issue that, you know, may qualify as, you know, a non-felony misdemeanor versus a felony. Those are totally different things that have totally different potential penalties.
Right. So a felony is the worst criminal charge. That carries with it a punishment from a year and a day to life in prison. You will not be charged with a felony at a city or municipal level. That's only in county court. Misdemeanors, on the other hand, carry anything from probation and fines to a year in jail. Both felonies and misdemeanors are split into three classes: A, B, and C. A being the worst, and C being, you know, the least of those, and the punishments kind of vary from there. Having
a lawyer understanding even that process is super important, isn't it?
It is, because the different types of felonies and misdemeanors affect, you know, they have a different effect on your record, your criminal record, your employment, and the different punishments that go along with them. There's just such a large range of what you get into with those different classes.
You can see why Brett hired her. Yeah. She's sharp. All right, now, when we come back, I do want her to walk us through an important process, which is, and we don't get this much in the criminal show, but I want to talk about just the process from the time that you are you know, arrested, kind of what happens from there, and why having a lawyer involved in that process is really, really important.
That sounds good. All right, we will pick up right there when we come back. As we go to break, a reminder, Hollis Wright is a great follow on social media, so wherever you are on social media, they are there as well. Instagram, YouTube, Facebook, a great educational, informational, legal resource, so you probably want to take advantage of that. Just search the term Hollis Wright and you'll find it there. Stay tuned. We'll be right back after this quick break.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with The Attorneys.
Welcome back in to The Attorneys. Thanks for joining us tonight. About to return to our conversation here. Before we do so, don't forget, attorneys from Hollis Wright standing by live to speak with you, going on all throughout the show tonight. They are standing by to speak with you, so take advantage of that opportunity. Josh?
All right, so Ansley, let's talk about this. In general terms, can you walk us through kind of the criminal process? Because I think there's a lot of confusion about, have I been charged? Am I technically arrested? I'm at the police station, but kind of walk through that process.
Absolutely. So generally the first thing is the arrest. Now that can occur, it occurs when a law enforcement officer has probable cause to believe that you have committed a crime. That can occur if the police officer sees you commit a crime. It can also occur if a citizen later swears out a warrant an alleged victim in a crime. Either one of those can happen. If it's the latter, where someone swears out a warrant, you might not know. You could be driving around and have no idea that there's a warrant out. You could get pulled over for a traffic citation and then find out that you have a warrant, which is unfortunate if that's how you find out, but that is the case. So you are technically arrested and in custody when you are not free to leave or move about. That is when you are in custody. Now the next step would be booking and bail, and that kind of goes along with the arrest. So when you're arrested, you are usually processed then into the jail. That is called booking. They get some information, and the law enforcement determines if you are eligible for bail. That bail number can depend on your criminal history, what the crime is, different things of that nature. There are 3 different ways that you or a family member or friend can post bail for you. The first way is through a bail bondsman. A bail bondsman, you have to pay 10 to 15% of the bail amount, and the bail bondsman keeps that money. It is non-refundable. So the second option is a cash bail. If you pay a cash bail, you're paying the full amount, but that is refunded. Or if you later have court fees, court costs, it will be applied to offset those numbers. And then the third way is a property bond. So if you have a family member who has property that can cover that amount, they can post that bond. They usually have to bring the deed by to the jail. But in the state of Alabama, you do have to make sure that that property is in the county where you're being charged. So those are the 3 ways to post bail. After booking and bail, you're going to have your arraignment. That is when you go in front of the judge and you're formally read the charges that are being brought against you. At that point in time, you can enter a plea of guilty or not guilty, but that's just your initial plea. It can ultimately be changed later through discussions and negotiations between your attorney and the prosecutor. After that point, typically there's a grand jury hearing. It kind of depends on the posture of your case. If your case starts in district court, which is the case where the case starts, usually in state court, it starts at district court. And then if you waive it to grand jury, it'll go to a grand jury of your peers who determine if there's probable cause for that to proceed to trial. It would then move to circuit court. You can also have things go straight to grand jury to determine if there's probable cause.
If you've had, for example, and I didn't mean to interrupt you, but if you've had, for example, a misdemeanor like a DUI, a DUI 1 first offense, does a grand jury even get involved in that?
No,
Okay.
typically not. Ultimately, if you have cases in district court that are misdemeanors, you can waive them to circuit court and they would go through a grand jury at that point, but usually no, that's either in traffic court or even you can have DUIs in a municipal or city court.
And is it key to get a lawyer involved in between the booking and bail process and the arraignment process? Is that when you really want to go get a lawyer?
Absolutely, because they still have a chance to talk to the investigators and the DA at that point, or whoever the prosecutor is. And the plea bargaining process, which I was going to get to shortly, it really occurs from the beginning of you being charged throughout the entire process. So the sooner that your attorney can speak with the prosecutor about your case, the better.
All right, I didn't mean to interrupt you. Go ahead.
Perfectly fine. So after grand jury typically is a pretrial period where there's often pretrial motions. Those motions can be about a lot of different things, but usually it's about evidentiary rulings. For instance, if you claim that a police unconstitutionally searched your home or searched your vehicle, you could file a pretrial motion to suppress the evidence that was found, and it would not be led into trial. Okay. Also, there's certain times that you have to put the prosecution on notice that you're using a certain type of evidence at trial. So those would be some situations when you have pretrial motions. After that, you get into the trial, obviously, which most people know about. They see it on TV. The state or federal government, whoever's prosecuting the case, and the defense, they put on opening arguments. They present different witnesses, evidence, testimony. They give closing arguments, and then ultimately a jury will decide on the guilt or innocence of the defendant.
Vast majority of cases never get there. Is that fair?
That is very fair.
Okay.
Most cases end in some kind of plea bargaining where the defendant pleads for a reduced charge or lesser fines or fees.
And in your assessment, in practicing in this area of the law, does the number of offenses someone have, if, for example, it's a first offense versus a fourth offense, does that weigh into the plea bargaining stage?
Absolutely. Okay. A prosecutor is going to be way less willing to give you a good deal if this is your fifth offense, which obviously makes sense. If it's your first offense, your attorney's usually going to be able to work out some kind of deal, whether it's in your best interest and you wish to take it or not. It's going to be a lot easier to get a good deal if it's your first offense.
So after trial, you generally go to the sentencing phase where you could be sentenced. Is there some level of negotiations with a lawyer in trying to make recommendations not to follow sentencing guidelines, as an example, for the following reasons? Is it important to have a lawyer in that stage too?
Absolutely. An attorney knows how to organize a sentencing memo, which is something that we file that tells the court and the state, hey, they have this education, they have this work history, they have this illness that could be terrible for them to be put into jail, different mitigating factors, as we call them, that just are reasons for the judge to vary from where you might fall on the sentencing guidelines.
When we come back, because I know we're going to break, we'll talk to Ansley about some rapid fire stuff. We'll rapid fire on some questions and whatnot that will be practical related issues that people see on a daily basis that they probably have criminal questions
Speed round.
Speed round today.
All right, speed round coming up next. Stay tuned. The final segment of The Attorneys coming right up.
I'm attorney Carter Clay with Hollis, Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys. Less than 6 minutes remaining in the show, so if you want to take advantage of that opportunity to speak with attorneys from Hollis Wright, you better get on the phone. The clock is ticking, as they say. A question we've got here, an individual says, if I'm pulled over by a police officer and asked for consent to search the car, do I have to let them do it?
Absolutely, you do not have to.
You do not have to.
You do not. You should always give a police officer biographical information, but you never need to let them search your car without a warrant. The Constitution protects you from that, and I would suggest that you not let them search.
Are there circumstances where there are certain questions you can answer that probably can keep you out of trouble without firing an officer up, where you show some level of respect and you're courteous? I mean, how do you recommend that? Because I know that's complicated. It's easy to say no to an officer, you're not going to search my car, but it's totally different to say no in a respectful way.
Well, you should always be polite when you're telling an officer they can't search your car, or any conversation you have with an officer. And I say that it should be polite because what people don't know is that officer who is making the arrest or searching your car often will play a role down the road in your case by either testifying against you, or they can speak to the prosecutor, and that can have and affect the outcome of your case.
And if you're respectful and he conveys that to the prosecutor, sometimes it probably can play to your advantage, can it?
Absolutely. The prosecutor is more willing to work on some kind of deal to help you out.
Yeah.
Another quick question we've got here. There have been a lot of changes in Alabama's DUI laws, including interlock requirements that have just begun being implemented in Alabama courts. In general, what is a DUI and how is someone charged with one?
A DUI is usually defined in one of two ways. Most people know blowing above a 0.08 or 8% blood alcohol content is a DUI, but the way that most people are charged in Alabama is just simply charged by driving under the influence. You do not have to blow over a 0.08. The officer can cite bloodshot eyes, smell of alcohol on your breath, or several different factors to show that you were impaired. Now, the interlock requirements are fairly new, and they're just now really being implemented in the state of Alabama, especially around Birmingham. That is a device that is a breathalyzer that's installed in your vehicle. You have to blow into it to start your car and drive. You have to blow below a 0.025. Now, if you blow above it, it locks you out for 5 minutes until you blow under that. And if you still can't blow under that, it'll lock you out for 30 minutes at a time thereafter. If you are convicted of a DUI the first time, you can elect to have it instead of having your license suspended, but every other conviction after that, and if you enter what's called a deferred prosecution program, you're going to have that interlock device.
The reality, too, is you don't even have to be driving to get a DUI in Alabama, do you?
You do not. All that the state has to prove is actual physical control of the vehicle, which means you can be asleep in the front seat or passenger seat and the keys can be in the car. You can be sitting in the front seat with the keys in arm's reach. You can still be charged even if the car is not on or moving.
What do you see, if you will, trends in criminal law? What do you see most often in this area? Like what's a common case for you guys? And I know it's comprehensive, but I mean, is DUI still a really significant volume of cases?
People are still getting DUIs very often, and it's crazy because there's so many ride-sharing services now with Lyft and Uber, but I guess once people are impaired, they just don't think to call the Uber. But it's still occurring quite often, and what people need to know is that the laws and the penalties are getting harsher and harsher on DUI. So it's always smarter to call that Uber.
Yeah, for sure.
We're just about out of time. Time enough for a final thought from the both of you. And Ansley, if you would, you go first.
Absolutely. I would just emphasize that an individual who knows that they might be facing charges soon should always call an attorney immediately. It doesn't matter if you haven't been charged. More can be done prior to you getting charged. You need an attorney with you from the very beginning.
Yeah, and I would just say, and I think we've harped on that issue today, Brett and Ansley, two of the best in this area. If you forget after today's show their firm, come to us. We're going to get you to them because Brett's one of the guys that I send a lot of our criminal stuff to that we get. There are certain types of cases that we handle in our firm. Criminal law is not one of those specialties, so we will send those cases out to someone else. And I know this, and I can speak for Ansley even though I don't know her as well as Brett, but Brett's willing to work with you if there are financial related issues on hiring a lawyer of that quality service. He's willing to work with you. So don't be afraid to call a lawyer to get advice, not only on the criminal case, but also on what is it going to take for me to defend myself using your law firm. They're willing to work with you. That's a common question. So I would just highly recommend the Bloomston firm. They do a great job, and just so glad Ansley was on today. You did a great job, by the way.
Thank you so much. I enjoyed it.
Great job.
Thanks so much to both of you, and thanks to you as well. We really are grateful each and every time you choose to join us on Sunday nights, and we will look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.